It is submitted that, therefore, the High Court has rightly refused to implead the appellant as a party respondent in the petition filed by the private respondent herein stop. The learned advocate appearing on behalf of the state of Gujarat has also opposed the present appeal as well as the application submitted by the appellant herein before the High Court and vehemently submitted that the appellant being one of the co-accused who is already charge-sheeted and against whom the trial has proceeded further has no locus or say in the petition filed by the private respondent herein as, even otherwise, the appellant cannot be said to even the affected party as while submitting the application under section 173 within bracket 8 CRPC, no relief is sought against the appellant and the relief is sought for one another co-accused, namely Sri Bhaumik, who is yet not charge-sheeted. Stop para. At the outset, it is required to be noted that the present proceedings arise out of the application submitted by the private respondent herein seeking further investigation under section 173 within bracket 8 CRPC against the one who is yet not charge-sheeted. Stop. Learned Chief Judicial Magistrate dismissed the said application against which the private respondent herein has approached the High Court by way special criminal application. Stop para. In the said petition, the appellant herein, one of the co-accused who is already charge-sheeted and against whom the trial is in progress, and though in an application under section 173 within bracket 8 CRPC no relief is sought against him, submitted an application to impleaded him as respondent in the said special criminal application, and the said application has been dismissed by the High Court by the impugned judgment and order. Stop. Therefore, the short question which is posed for consideration of this court is whether in the facts and circumstances of the case, the appellant, one of the co-accused against whom the charge sheet is already filed and against whom the trial is in progress, is required to be heard or has any locus in the proceedings under section 173 within bracket 8 CRPC. Stop para. Having heard learned counsel appearing on behalf of the respective parties and the private respondent herein, we are of the opinion that as such no error has been committed by the High Court dismissing the application submitted by the appellant herein to implead him in the special criminal application filed by the private respondent herein, challenging the order passed by the learned Chief Judicial Magistrate rejecting his application for further investigation under section 173 within bracket 8 CRPC with respect to one another accused, namely Sri Bhaumik, against whom no charge sheet has been filed till date. Stop para. Therefore, it is not at all appreciable how the appellant against whom no relief is sought for further investigation has any locus or any say in the application for further investigation under section 173 within bracket 8 CRPC. Stop. How he can be said to be a necessary and a proper party. Stop. It is required to be noted that, as such, even the proposed accused shall not have any say at this stage in an application for further investigator as observed by this court in the other case. Stop para. In that case, after considering one another decision of this court, it is observed and held that There is nothing in section 173 within bracket 8 CRPC to suggest that the court is obliged to hear the accused before any direction for further investigation is made. Stop. Therefore, it can be seen that Rule 51 of the Gujarat High Court rules has no application at all. Stop. In view of the above and for the reasons stated herein above, there is no substance in the present appeal and the same deserves to be dismissed and is accordingly dismissed. Stop.